May it please your lordships and your ladyship, we were looking at the question of reading down, and of course our basic submission is that in accordance with the established tests, any reading down cannot go against the grain or reach a conclusion inconsistent with a fundamental feature. And you already have our submission that the requirement of personal service is not just a fundamental feature of the relevant legislation, it is the sole feature, and writing it out would be an obliteration of the heart of the section. It's important, we say, also to remember that it's for the legislature to strike the relevant balances here. So insofar as any variation to the test would create a new test being suggested by Mr. Henley, then we are already invading the sphere of legislative judgment. Mr. Henley, for example, advocates a test of normality which is unrelated to the individual contract. Pause to ask how that could possibly work in practice. How is an individual to know whether they're within Article 11 or not when they join, if their classification depends on how much they in fact do, or how much they in fact do personally in practice? And why does it depend on just them? Does one look at others' practice, and which others? But whatever test is imposed, it's a new test, and it's unthinkable that Parliament would introduce a new test, whether based on practice, contract, or anything else, without extensive consultation with industry and indeed the trade union movement to explore all its implications in context. The second point relevant to that aspect is that the authorities tell us that if there is going to be a reading down, it has to be done with the precision of a legislator. And if we could go here to the Lambert case, R versus Lambert, at tab 22, it begins at 1380, but the passage I'd like to read you is at paragraph 80, page 1420, 1420, and it's in a speech of Lord Hope. And he says this: the second point, as I said in paragraph 110 of my speech in R&A, number 2, is that great care must be taken in cases where a different meaning has to be given to the legislation from the ordinary meaning of the words used by the legislator, to identify precisely the word or phrase which, if given its ordinary meaning, would otherwise be incompatible. Just as much care must then be taken to say how the word or phrase is to be construed if it's to be made compatible. The justification for this approach, the use of section 3.1, is to be found in the nature of legislation itself. Its primary characteristic for present purposes is its ability to achieve certainty by the use of clear and precise language. It provides a set of rules by which, according to the ordinary meaning of the words used, the conduct of affairs may be regulated. So far as possible, judges should seek to achieve the same attention to detail in their use of language to express the effect of applying section 3.1 as the parliamentary draftsman would have done if he'd been amending the statute. It ought to be possible for any words that need to be substituted to be fitted into the statute as though they'd been inserted there by amendment. If this cannot be done without doing such violence to the statute as to make it unintelligible or unworkable, the use of this technique would not be possible. It will then be necessary to leave it to Parliament to amend the statute and to resort instead to the making of a declaration of incompatibility. And we say that the suggestion effectively made by Lord Henley falls foul of each of these requirements. You can't simply say, oh, the legislation covers Deliveroo riders. Which Deliveroo riders? Deliveroo riders in the Camden area, the no longer existent Camden area, riders in the Camden area in 2017, the particular individual who gave evidence in the case. What is necessary is to have a principled redefinition. But then the problem with a principled redefinition is the one that I've already indicated. The court is immediately drawn into making new rules, whether they're rules about normality or dominant purpose or any other formulation one would come up with, which belong entirely in the sphere of the legislature and would trespass into the legislative function. It's very different, just to flesh out the point I made before lunch, very different from what was being done in the Wandsworth case. If one turns to that, it's in tab 25, and the relevant bit is 2266. You'll remember here that the issue here was the accidental inclusion of Parks Police in a provision which was intended only to exclude ordinary constables. And the court said, well, you could just treat the Parks Police as excluded. And at page 2266, paragraph 74, they say this: we do not believe that our inability to formulate a draft amendment to section 280, which definitively distinguishes between the classes of employees whose exclusion is or is not justified, is fatal. As the authorities from Guardian Mendoza onwards made clear, it is not necessary, even though it's often useful, for a court to commit itself to such a formulation. In our view, it would be sufficient for us to say that when construed in accordance with section 3, section 280 of the 1992 Act, the exclusionary provision, does not apply to the class with which we are concerned. That is to say, persons employed as constables by virtue of Article 18 of the 1967 Order, or Section 77 of the 207 Act, as a very precisely and indeed statutorily defined category who could be cut out of the list. The question is then whether such a construction would go against the grain of Section 280 or contrary to its fundamental features. We do not believe it would. We regard it as sufficiently evident that the primary statutory intention was to exclude from the scope of the 1992 Act employees of traditional police forces. And they go on to justify that view. Bottom of the paragraph, that being so, we regard it as likely that Parliament was focused on the more substantial police forces who employ constables and simply failed to appreciate the effect of the statutory language on this very small group of employees. So no problem there in saying, without a redraft, that group should be taken out of the exception. It leaves no relevant uncertainty, and it fulfills what the court found to be the true intention of Parliament, i.e. that only ordinary police officers should be excluded. It's impossible to do such an exercise here. It would be necessary to undertake a fundamental redrafting of the section, which I suggest would be difficult to do in relation to Deliveroo riders specifically. It would need plainly to address the wider categories of individuals with or without claims to be in employment relationships, and it would be impossible for this court to undertake, requiring as it would a view across the field of employment relationships and near employment relationships as to who should be caught and who shouldn't, and that is a full parliamentary function. So we say that there's no scope for reading down. The reading down suggested would be a reading out, and having an entirely new section with a new focus would be a matter for Parliament, and wouldn't either specifically include the very individuals who are subject to this case, the Deliveroo riders in Camden in 2017. So we say that this is not a case for reading down. Then finally, can I seek to address the question my Lord Briggs put to me this morning, although not sure that I have any more enlightened an answer to it. We would accept that employment relationship has an autonomous meaning, that it's a necessary precondition of the article, the relevant part of the Article 11 right, that there is an employment relationship. That's the starting point. But secondly, we would say that determining whether there's been a breach of a positive obligation engages the margin of appreciation. And Lord Reid in Elan Kane tells us that that is particularly important in relation to positive obligations.
I thought he was saying there was a margin of appreciation as to whether there was a positive obligation.
Yes.
But you've expressed it in relation to whether there was a breach of a positive obligation.
Yes. One could put it both ways round.
Yeah.
And we say, thirdly, that the margin also applies to justification if it's necessary to resort to 13.2. So what we say is employment relationship is a necessary precondition, but it doesn't tell you anything about the content of the right. The fact that you are in an employment relationship will no doubt normally mean that you have the right to join a union, but there may be circumstances in which you don't, or in which your exclusion is justified, and one can imagine various circumstances where that is so. A fortiori, where one comes to the more far-flung suggestions about collective bargaining. But that, we say, is the structure of it.
So are you saying that the existence of an employment relationship is not coextensive with the right to engage in compulsory collective bargaining?
Well, it's a precondition of the right to engage in collective bargaining.
So where do we find the content?
Well, you have to find the content from what is handed down by Strasbourg, and in this case, Strasbourg tells us very clearly that there's no compulsory rights. And generally, in relation to margin of appreciation, one always has to examine the putative right in its context and look at the arguments for and against recognising its existence and recognising justifications for denying it. But it's only triggered, that whole analysis is only triggered once the necessary precondition of an employment relationship is present. I don't know if that's an all-encompassing answer to my Lord's question, and in our submission it's very difficult to look at any of these articles and derive very much from the language, and in fairness that's not the approach of the Strasbourg court, but that applied to certainly Article 11 in the circumstances we are addressing is the structure of the relevant provisions in our submission. Now, Unless I can help your
Can I
lordship's
just,
ladyship.
there's one question which
Yeah.
perhaps arises somewhat out
Yeah.
of the questions you've just been asked, but you submitted this morning that as far as Article 11 relates to collective bargaining, it requires an employment relationship.
Yes.
But are you suggesting by that some other relationship is sufficient if it's dealing with simply the right to form a trade union?
Well, I'd suggest that something less was sufficient to form a trade association.
Yeah, I understand that.
And there is, I think my primary answer to that would be that you do have to be in an employment relationship in order to join a trade union. The reason I'm hesitating for a moment is I'm trying to accommodate, perhaps as part of an alternative analysis, the Manole case, where one could say, well, there is a right to join bodies which call themselves trade unions but may on analysis not be real trade unions, may not be bargaining bodies, which may extend beyond employment relationships. If you're considering the Manole type situation where the real question is, can we join this organisation which is for promoting occupational interests but is not a bargaining body? My first answer would be, well, you do need to be in an employment relationship in order to join it if it's really a union. But my alternative fudged answer in the light of Manole is that there may be organisations which sit on the boundary as to whether they're trade unions or not, and the Manole case possibly suggests that in those situations an individual may have a right to join something which calls itself a trade union. But if we're talking about trade unions which bargain with employers, then there has to be an employment relationship.
Yes, thanks very much.
Unless I can assist.
Thank you very much, Mr. Dean. Very grateful. Mr. Sills.
May it please your lordships and your ladyship, on behalf of the Secretary of State, I propose to make my submissions under the following 5 headings. First, to look at the nature of the statutory scheme for recognition under Schedule A1. Secondly, to look at how the approach to who is a worker has been impacted by this court's decision in Uber and Aslam. Thirdly, to consider the impact of the Article 11 jurisprudence, both in Strasbourg and domestically, on the question in this case. Fourthly, to look specifically at the question of justification. And finally, briefly, to deal with the question of reading down. By way of preamble, before turning to the first of those, we would observe that the appellant's written case appeared to be founded on 3 key propositions, each of which we would submit as a non sequitur. First, that because Article 11 provides rights to everyone, everyone must be able to avail themselves of its protection in terms of trade union rights. That proposition has now been abandoned by Lord Hendy in his oral submissions. Secondly, because the right to engage in collective bargaining has been recognised as an aspect of Article 11, it follows that Article 11 guarantees a right to compulsory collective bargaining with an employer. That also has now been abandoned by Lord Hendy. And he's therefore left with only the third of the 3 propositions. We submit non sequiturs. Because the United Kingdom has chosen to confer a limited right to compulsory collective bargaining in certain circumstances, it must do so in all circumstances. And for the reasons we will develop, we submit that that is not a proper inference. I turn then to the first of the 5 headings, Schedule A1 to the 1992 Act, because this was a legislative scheme introduced by the Employment Relations Act 1999, which was a centrepiece of the employment legislation introduced by the Labour government, which had come into power in 1997. And it marked a decisive break from the previous government, where there'd been no general right to trade unions to compulsory collective bargaining at all. And indeed, this is an area where the legislation has ebbed and flowed with the political tides. For reference only, the changes in the law are summarised in the Fairness at Work research paper in the Intervenors Bundle, which is Intervenors Bundle tab 18, pages 360 to 362. But briefly, the Industrial Relations Act 1971 made provision for registered unions to apply to the National Industrial Relations Court for recognition. But in fact, those provisions were little used because the TUC organised a successful campaign to boycott registration. Then the Employment Protection Act 1975 introduced a different right to apply to ACAS, which could make recommendations on recognition. But then the Employment Act 1980 completely repealed any right to compulsory collective bargaining, and that remained the position until the legislation we're concerned with was introduced in 1999 with a degree of compulsory recognition. But it was always envisaged that the recognition procedure would be limited in scope, and we see that from the Fairness at Work white paper, which I would ask the court to turn up if I may. It's in the Intervenors Bundle, tab 17, begins at page 314, and this was the white paper which led to the legislation we're concerned with, published in May 1998. Now, collective rights were dealt with in Chapter 4 of the white paper, which is at page 331. In fact, it begins at 329. And I'll take the court to some passages from it, but in our submission, just to sort of indicate where I'm going, the legislation embodies 4 key principles. First, the primacy of voluntarism. Secondly, the importance of legal certainty in the operation of the recognition machinery. Thirdly, balancing trade union members' rights against those of non-members. And fourthly, balancing the interests of workers and the interests of employers. And to seek to make good that analysis of the purpose and justification for this legislation, we can pick it up at page 330, paragraph 4.10. The government accepts the importance of voluntary choices and believes that mutually agreed arrangements for representation, whether involving trade unions or not, are the best ways for employers and employees to move forward. Where agreements are reached voluntarily, they are most likely to be successful and suited to the needs of the enterprise. However, there will be occasions where employees want the benefit of representation at work but are unable to secure agreement to it from their employer. The government believes strongly that these will form a very small minority of cases, and that even then, the prospects of voluntary agreement must be exhaustively examined. But as part of setting in place minimum standards, the government will bring forward legislation to provide for representation and recognition where a majority of the relevant workforce wants it. So that's the voluntarism principle, the primacy of voluntarism. Next, certainty, and we can pick that up at 4.13 on page 331. But it is vital that a clear framework and process are established governing decisions on trade union recognition. We must encourage dispute resolution. Neither the business nor employees will gain from protracted, possibly hostile disagreement, which can only damage future relationships, whether or not a trade union is eventually recognised. 4.14, the government invited the CBI and TUC to discuss these issues to try to narrow the differences. Following discussions, those organisations produced a statement setting out the points they agreed in whole or in part and recording their remaining differences. The government's grateful for their efforts. 4.15, the government is proposing a new system of recognition. Its starting point is voluntary agreement. Only where this proves impossible should another means be invoked. Setting out the procedure will help ensure the employers, employees and trade unions all understand clearly what will happen, against certainty. If they cannot agree, this should in practice lessen the likelihood of further stages of the procedure being necessary. 4.16, the government believes that where a clear majority of employees wish to be represented by a trade union, the new procedure will enable that union to be recognised by their employer without the disputes which have resulted from recognition claims under the current law. A statutory procedure offers a means of settling disputes without industrial action. The reason it is important to have clear support at the workplace is twofold. First, without real and substantial support amongst employees, collective bargaining simply will not work. Second, since collective bargaining has an impact on all employees, not just those claiming union representation, it's right that it should only be granted in circumstances where substantial support is demonstrated. And that's the third principle, balancing the rights of union members and non-union members. 4.17, in drawing up its proposals, the government has been determined to introduce a procedure which will work, and this comes back to certainty, which will improve fairness and which will complement and enhance competitiveness, prosperity and growth. To deter insubstantial claims, the new procedure will rest on trade unions being able to demonstrate initially they have a baseline support among employees before a recognition claims can succeed. The group of employees whom the trade union recognition will apply, if they choose it, the bargaining unit, will be clearly defined to avoid disagreements. Again, certainty is very important. And then dropping 3 lines down, in many small firms, employment relations are managed not just at an individual level but on a personal level. In these circumstances, statutory requirements on trade union recognition would be inappropriate. So the provisions will not apply to companies below a set threshold. That's a 21 worker point. Just as employees have the right to join or not join a trade union, employers will have available a parallel procedure to end recognition arrangements if employee support for them reduces significantly, and to deter unwarranted attempts to obtain recognition or derecognition. There will be a minimum time period to allow employment arrangements to demonstrate their validity. So there we have the fourth principle, balancing employers' rights against employee rights. And that in essence is the justification, policy and principle which underlies the legislation with which we are concerned.
Was there any reference to Article 11 or the Convention in the White Paper?
None that I'm aware of, my lady. Turning then to the legislation itself, I would like to begin, before we go to Schedule A1, by looking at Section 179 of the 1992 Act, which is at page 674. I don't think we've looked at Section 179 yet, but it is important in this context. Page 674, Section 179, whether an agreement intended to be legally enforceable contract. 1. A collective agreement shall be conclusively presumed not to have been intended by the parties to be a legally enforceable contract unless the agreement A is in writing and B contains a provision which, however expressed, states that the parties intend that the agreement shall be legally enforceable contract. But then 2 is the converse. A collective agreement which does satisfy those conditions shall be conclusively presumed to have been intended by the parties to be a legally enforceable contract. And this is an important provision because it's section 179 which entails that the scenario that arose in Demir and Turkey wouldn't arise in the United Kingdom. Because the interference in Demir and Turkey was parties freely entered into what they wanted to be a legally binding collective agreement. The state struck it down, ab initio. That couldn't happen here because of section 179. And in the Unite case, which my learned friend Mr. Jeans took the court to in some detail, you will recall that section 179 and the availability of legally enforceable collective agreements where they're entered into was great weight was placed on that provision by the Strasbourg court in reaching the decision that there was no interference with Article 11. Turning then to the schedule, I briefly would like to refer to just a few parts of it. You will appreciate, however, the court will appreciate it's a very long and complicated provision, and that's because it's difficult to decide exactly how you draw the line in these sorts of schemes, and that's why Parliament has difficult choices to make, and they need to be respected. Paragraph 1 of the schedule is at page 725 in the same bundle. A trade union or trade unions seek recognition to be entitled to conduct collective bargaining on behalf of a group or groups of workers may make a request. And we just note that the definition of workers runs right through this schedule like the name of a seaside town through a stick of rock. At 726, paragraph 2, this paragraph applies for the purposes of this part of this schedule. References to the bargaining unit are to the group of workers concerned or the groups taken together. At page 728, paragraph 3, subparagraph 2, the meaning of collective bargaining given by section 178 shall not apply. References to collective bargaining are to negotiations relating to pay, hours and holiday. So it's a limited set of matters which it refers to. And just moving through swiftly, we see some other important limitations. For example, paragraph 6 at page 732, the request is not valid unless the union or each of the unions has a certificate of independence. So non-independent unions may not seek to invoke this limited right. And then at paragraph 7, page 733, the request is not valid unless the employer, taken with any associated employer or employs at least 21 workers on the day the employer receives the request. Now, we could spend the rest of the afternoon going through various limitations and conditions in this schedule. The key point is first that the concept of a worker is absolutely central and definitional to this scheme. And secondly, that this is necessarily a scheme which makes a huge number of policy choices about the limitations and scope of the right that it provides. And before leaving it, I simply note that this schedule has now been in place for nearly a quarter of a century under all colour of government, Labour, Coalition and Conservative. There hasn't been any significant attempt to repeal or significantly amend it, and therefore it is now a long-standing provision which has, as I say, survived several changes of government. So that's important context in our submission to considering the questions in this appeal. I turn then to my second heading, which is the importance of the Uber and Aslam case. Now, the history of this case is slightly anomalous in that the Uber decision had not been promulgated by this court at the time of the CAC decision, nor indeed at the time of permission for judicial review being considered, nor indeed, I think, at the time of the oral hearing in the Court of Appeal, never mind at first instance. So it's come late in the day. But in my submission, it's an important decision which is part of the landscape in considering who is a worker for the following reasons. That although Uber arrived too late for the CAC and Mrs. Justice Simler, it does shed light on how courts and tribunals should approach the question of worker status going forward. And as you're aware, it was considering worker status in respect of the very similar definitions which apply under the Employment Rights Act, national minimum wage legislation and the working time regulations. But the key insight in our respectful submission in Lord Legate's judgment is that the question of who is a worker should be treated first and foremost as a question of statutory interpretation, statutory construction, not with the starting point of the contract. And my learned friend Lord Hendy has taken you to a number of passages in the Uber decision. I wanted to take the court to just one more, which is paragraph 87 in Lord Legate's judgment, which is at page, forgive me, 2510. There he said, in determining whether an individual is a worker, there can, as Baroness Hale said in Bates van Winklehoff...
Sorry, paragraph?
Paragraph 87.
87, thank you.
In determining whether an individual is a worker, there can, as Baroness Hale said in Bates van Winklehoff, be no substitute for applying the words of the statute to the facts of the individual case. At the same time, in applying the statutory language, it's necessary both to view the facts realistically and to keep in mind the purpose of the legislation. As noted earlier, the vulnerabilities of workers which create the need for statutory protection are subordination to and dependence upon another person in relation to the work done. As also discussed, a touchstone of such subordination and dependence has long been recognised in employment law, the degree of control exercised by the putative employer over the work or services performed by the individual concerned. The greater the extent of such control, the stronger the case for classifying the individual as a worker who is employed under the workers' contract. And a
striking feature of the CAC decision is that they look at how the contract operated in practice, that is, after it was concluded, which under traditional contractual interpretation principles, you can't look at how the parties have operated it, or only in very limited circumstances. And here, I suppose, as soon as Deliveroo set itself up, or at least rose above the 21 employee limit, one might have had to decide whether or not they were workers without having all that experience of looking at whether they did actually substitute or not. So how is the sort of experience over a long period, how does that fit into how you construe the statute or the contract or either?
Well, as a matter of law, my lady, the decisions in AutoCleanse in the first instance and then Uber do indeed depart from the traditional contractual approach, which one does look and perhaps even start in the Uber case with how the contract operated in practice, and for obvious reasons, courts and tribunals are invited not to be overly impressed or influenced by written contractual terms which may not reflect the reality. So undoubtedly one has to look at the realities. It is an unfortunate feature, and make no bones about this, that defining employment, contracts of employment and defining worker status has proved very difficult for the courts for obvious reasons, which is, among others, that these are nuanced relationships. Sometimes employers, and Uber was an example of this, sometimes employers put in place contractual terms which are obviously artificial in an attempt to achieve a particular result. And so one doesn't envy the CAC having to look at the whole set of realities. But unfortunately, there's no substitute for doing that. But it's important, and this is why we say Uber's important. Just because these are complex and nuanced exercises doesn't mean that one goes, as it were, appealing to Article 11 in deciding the extent of these statutory rights. What Uber says the courts and tribunals can and must do is adopt a purposive approach. So they can look at the realities, they can say this is how it operated in practice, they apply the statutory test, and they apply a test of substance, but none of that takes us into a realm of Article 11. That's simply how Lord Leggatt has decided, with the rest of this court in that case, that economic realities should really be what applies. And so the way one approaches it is to say, well, look at these arrangements, to try and sort of boil down what Lord Leggatt seems to us to be saying. He says, who did Parliament intend should benefit from this scheme? But that's about the scope of domestic legislation. It's got nothing in our submission to do with Article 11. And looking at it domestically, the answer to that question is Parliament intended that workers should have these rights. Workers are defined under Section 296, limbs A and B. But Uber says in conducting that exercise, you conduct a purposive approach, which is multifactorial. It looks at control, it looks at dependence, and all of the things that Lord Leggatt sets out, and that gets you to the right result. That's what this legislation is for.
So in one sense, it doesn't, the domestic definition of a worker doesn't apply in the autonomous concept of a worker for the purposes of Article 11.
Well, no, they're two different things.
Yes.
I just respectfully agree. The autonomous concept of worker under Article 11, there's no consensus within the Council of Europe states as to what that is. The Strasbourg Court reaches towards it in The Good Shepherd and refers to the ILO materials, but that's, as it were, not the finished article. But here we're concerned with who should benefit from a particular statutory right, where one does look to the statute. And unless, I'll come to Article 11 in a moment, but unless there's some kind of egregious interference or something.
But if one starts with Article 11, first of all, you have to see whether there's an employment relationship. Secondly, do you accept the employment relationship test as set out in The Good Shepherd?
Well, we would accept that from the point of view of Article 11, that's the that's, as it were, the best we've got. The Good Shepherd is the best we've got. And it's clear that one does need an employment relationship. And certain indicia of that are...
to join a trade, to form or to join a trade union.
Yes, but I think where we submit that one has to be a bit careful is in then trying to sort of map that definition, which is not hard-edged, onto the domestic legislation, where it's the wrong, in our submission, it's the wrong starting point. The correct starting point is the domestic legislation, interpreted in accordance with Uber, and one then examines, and this is what I'll come to now, the third limb of my submissions, does it involve an infringement of Article 11 that the UK has organised its legislation in that way? So, coming on to Article 11, first of all, there's no universal or even broad consensus amongst the Council of Europe states as to what right to collective bargaining there should be. We've set this all out in our case, but rates of coverage for collective bargaining vary hugely across the Council of Europe. Moreover, according to the ILO, and we've set the references out in our case, there are some states, for example Germany, Italy and Ireland, which the Republic of Ireland, which have no compulsory collective bargaining at all. And certainly the appellants have not been able to submit that there is a consensus across the member states on that point. So in that respect, there's a distinction, for example, with the Demir case, because in Demir, the court found that there was a consensus across all Council of Europe states that public servants had the right to join trade unions, and that was very influential on the court's decision in that case. But that is not the territory we're in here. And so we then come to this question: what do the Strasbourg authorities tell us about the content of Article 11 in the collective bargaining sphere? I will adopt respectfully my learned friend Mr. Jeans's submissions on the threshold test of employment relationship, the Manole case and the Good Shepherd case. I turn to the question of, and I note in passing that in terms of the relevance of international instruments on that question, we do submit that the Court of Appeal perhaps too rigidly simply adopted the ILO definition and regarded that as determinative. Our submission, again, it's all set out in our written case at paragraphs 28 to 34, is that whilst the international instruments may be a useful resource and source, they are not determinative, even in Strasbourg, never mind in the United Kingdom, of who falls within the relevant definitions. But coming then to the authorities on Article 11, in summary, we would submit that there have been found to be breaches of Article 11 really in only two scenarios. The first scenario is in cases such as Demir, where the state has actively prevented collective bargaining taking place. Secondly, there are cases such as Wilson and Danilenkov, where there has been victimization of those who have sought to engage in collective bargaining or other trade union activities. If you look in the results, that's really more or less it, we would submit. What's common to those is that the Strasbourg court has characterised the essential element of Article 11 as being to protect the individual from arbitrary interference by public authorities with the exercise of their rights. Now, you've been taken at some length to most of the authorities. I would like to take the court just to two to illustrate these points. First, to the RMT case, which I don't believe the court's been taken to yet, which is tab 65, page 2960. Now, this is a case about the right to strike, not about the collective bargaining per se, but it's an important statement of principle. It's also, you will recall, the case that the Strasbourg court looks at the protections given to trade unionists cumulatively. So it looks at how is collective bargaining protected, also how is the right to strike protected, because these are all ways of a union seeking to persuade an employer to accede to demands in terms of terms and conditions and so on. Just if we could go to paragraph 85 of RMT, which is at page 2974, and in the first column, about 10 lines from the foot of the page, the court says this: the right to collective bargaining has not been interpreted as including a right to a collective agreement. The Demir judgment, where the court observed that the absence of any obligation on the authorities.
What paragraph number, sorry?
Paragraph 85.
Thank you.
And I'm about 10 lines from the foot of the page, my lord.
Okay.
It doesn't entail the right to a collective agreement. C. Demir, where the court observed that the absence of any obligation of the authorities to actually enter into a collective agreement was not part of that case. Nor does the right to strike imply a right to prevail. As the court has often stated, what the convention requires is that under national law, trade unions should be enabled, in conditions not at variance with Article 11, to strive for protection of their members' interests, C. Demir and Good Shepherd, the appellant and its members involved in the dispute were largely able to do in the present case. The challenge there was to the balloting and notification requirements in the strike legislation. Then at 86, in previous trade union cases, the court has stated that regard must be had to the fair balance to be struck between the competing interests of the individual and of the community as a whole. Since achieving a proper balance between the interests of labour and management involves sensitive social and political issues, the contracting states must be afforded a margin of appreciation as to how trade union freedom and protection of the occupational interests of union members may be secured. In its most recent restatement of this point, and referring to the high degree of divergence it observed between the domestic systems in this field, the Grand Chamber considered that the margin should be a wide one, see the Good Shepherd. The applicant relied heavily on Demir, in which the court considered the respondent state should be allowed only a limited margin. The court would point out, however, that the passage in question appears in the part of the judgment examining very far-reaching interference with freedom of association, one that intruded into the inner court, namely the dissolution of a trade union, or the dissolution of a collective agreement. It's not to be understood as narrowing decisively and definitively the domestic authorities' margin of appreciation in relation to regulating, through normal democratic processes, the exercise of trade union freedom within the social and economic framework of the country concerned. The breadth of the margin will still depend on the factors that the court, in its case law, has identified as relevant, including the nature and extent of the restriction on the trade union right at issue, the object pursued by the contested restriction, and the competing rights and interests of other individuals in society liable to suffer as a result of the unrestricted exercise of that right. The degree of common ground between the member states of the Council of Europe in relation to the issue arising in the case may also be relevant, as may be any international consensus reflected in apposite international instruments. So that's how the point is put in RMT. And finally, in that decision, at paragraph 103, the court said, this is page 2977, it has been recognised in the case law, as has been recognised in the case law, it's legitimate for the authorities to be guided by considerations of feasibility as well as of the practical difficulties which for some legislative schemes may well be large scale, to which an individuated approach could give rise, such as uncertainty, endless litigation, disproportionate public expenditure to the detriment of the taxpayer, and possibly arbitrariness. And we refer to that because, again, we submit that that accords with one of the four purposes of this legislation, which is legal certainty, to have clear lines as to who falls within and who falls without the legislation insofar as it's possible to do so. The other case that I wanted to refer to briefly was my learned friend Mr. Jeans referred to Unite as well the last word on this. In fact, there's an even more recent authority dealing in general terms with the scope of Article 11, and that's the Association of Civil Servants and Union for Collective Bargaining against Germany, which is in the interveners bundle, tab 16 at page 291. That was a case where the union sought to challenge a scheme which provided that minority unions wouldn't have collective agreements recognised. So again, effectively annulling a collective agreement. The relevant passage is at paragraphs 54 onwards, and it goes from paragraph 54 at 305 through to paragraph 60 at page 306, and critically at paragraph 59, again the court says the right to collective bargaining has not been interpreted as including a right to a collective agreement. Halfway down paragraph 59. So there is no requirement under the Strasbourg jurisprudence to have a compulsory right to collective bargaining.
Well, that refers to a collective agreement.
Yes.
Does that mean the product of the collective bargaining?
Well,
or does it mean an agreement to negotiate?
I must confess, I'd interpret it as the latter.
I see.
And
right.
If one goes back to 58, that seems congruent, because the essence of a voluntary system of collective bargaining, it must be possible for trade unions which is not recognised to take
yes.
steps. So that's a very recent restatement of the principles upon which we rely. I turn then to the domestic authorities, and in particular the four Court of Appeal authorities in this area. And we submit that the Court of Appeal has gone somewhat further than the Strasbourg jurisprudence permits it to or requires it to, and therefore one has to be a little bit cautious about this. And we respectfully adopt my learned friend Mr. Jean's submission, specifically that Lord Justice Underhill went too far in the Boots case in deriving from Unite the proposition that in some circumstances there may be a duty on the state to confer a right to compulsory collective bargaining. We respectfully adopt his submission for the reasons he gave. However, in any event, we submit the domestic authorities don't go nearly far enough to be of benefit to Lord Hendy and the submissions he seeks to put forward in this case. And I'd like to turn to them briefly. First of all, the Boots case itself, paragraph 68, which is at tab 41, page 2155.
Sorry, paragraph?
It's paragraph 68 of Boots.
68.
Paragraph 68, my lord, yes. Which is at page 2155. Because what and I don't think the court's been referred to this yet, what Justice Underhill said there was this. Looking at the point more generally, the observation at the end of paragraph 13 of Sir Brian Keith's judgment seems to be important. The devising of a statutory scheme of recognition inevitably requires a large number of detailed choices about both substantive and procedural matters, seeking, as Mr. Stillitz put it, to balance and calibrate the interests of multiple stakeholders, e.g. workers, employers and competing trade unions. There will inevitably be some choices which not only could have been made differently, but could have been made better. But I think it is clear from the case law of the ECHR referred to above that Article 11 cannot be used as a tool to challenge this or that arguably suboptimal element in a scheme, providing that a fair balance has been struck. Both before and after Demir, the court has emphasised the wide margin of appreciation that must be accorded to member states in this area. And with respect, we would submit that all of these cases, and indeed this one, amounts to precisely what Lord Justice Underhill counselled against, i.e. a challenge to this or that arguably suboptimal element of the scheme. That's exactly what the appellants are seeking to do here, because they say we should be included, we don't like the definition of worker. That's not what Article 11 requires, according to the Court of Appeal. Turning to the Wandsworth case briefly, two important features of that. First of all, that was a case where Article 11 was relied upon in combination with Article 14, the anti-discrimination provision. And this comes back to a point my Lady Rose made yesterday, which is that, well, if you've got a scheme, does it have to operate across the board? And it is right to say that in the Wandsworth case, essentially the way that case went was that there's a right to be consulted on collective redundancies. Parks constables, through what would appear to be an error of the legislators, were excluded by accident. And the way their case was put was Article 14, saying that's discriminating against us in your Article 11 provision, and unless you can justify it, then that's a breach of the combined articles. The key point about that is that, as you may recall, the Secretary of State was able to offer no justification whatsoever in that case for the exclusion of Parks constables. So once you had got over the hurdle of showing a breach of Article 14 combined with Article 11, it doesn't matter how wide your margin of appreciation is, if you've got nothing, which is the unfortunate position I represent.
And the status was being a Parks constable, was it? It
was simply that there was some exclusionary legislation, yes, and the Article 14 was, yes, being a Parks constable. That was the status. And it's a bit like the Gillam case in this court, where judges were excluded from the whistleblowing legislation. The status relied upon combining Article 10 and Article 14 was being a judge. And this court found in that case that wasn't justified. So,
but in that circumstances, you're just looking at whether the legislation or whatever is within the ambit of Article 11 rather than whether there's been an interference.
Indeed, my lady, precisely. So that's the Wandsworth case. We then turn to the third of the four cases, which is the IWG case, the Cordon case as it's referred to. That was another challenge to Schedule A1. In that case, there was already a collective agreement in place, but the IWG sought to challenge it, wanted a different collective agreement with a smaller bargaining unit. That was the issue in that case. And it was Lord Justice Bean who gave the main judgment in that case. And we can see what he said at tab 53, page 2548. In paragraph 16. 61, he said, Unite the Union and United Kingdom is a still more dramatic retreat from para 154 of Demir. In rejecting Unite's challenge to the abolition of the agriculture...
Sorry, paragraph?
Paragraph 61.
It's actually on 2549.
I apologise, it's
yes.
2549.
Yeah.
So he saw Unite as a retreat from Demir. In rejecting Unite's challenge to the abolition of the Agricultural Wages Board, the Grand Chamber noted, in contrast to the Turkish statute in Demir, the UK law did not restrict employers and trade unions from entering into voluntary collective agreement, nor from making them legally enforceable contracts pursuant to agreement in writing under Section 179, nor from having terms of collective agreement incorporated into individual employee contracts. Thus, said the European Court of Human Rights, the applicant is not prevented from exercising its right to engage in collective bargaining. They reached that conclusion despite the fact that legally enforceable collective agreements are rarely, if ever, made in practice in the UK, and that while in theory a trade union representing agricultural workers could invoke the compulsory recognition machinery under Schedule A1, the need to show a minimum of 20 workers in the proposed bargaining unit meant that the employees of all but the largest farming enterprises would not qualify. I therefore agree the summary of the Strasbourg case law in Lord Justice Underhill's judgment in Boots and the judgment of this court in Vining, that to the extent that the rules of any statutory scheme constrain access to collective bargaining for a particular trade union or its members, the constraints will have to be justified by relevant and sufficient reasons. That, we submit, is where Lord Justice Bean repeats, we would say, the over-interpretation of Unite, and it must strike a fair balance between competing interests at stake. But in assessing that justification and choice made by Parliament, should be given a wide margin of appreciation. I also consider the case law indicates that Lord Justice Underhill was right to say in Boots that complaints based on the denial of a right to compel an employer to engage in collective bargaining face an uphill struggle, but are not excluded altogether. Now, again, we say the error in Boots is repeated there, but the overall effect, it doesn't really have any consequence in this case, because my learned friend Lord Henley faces precisely that uphill struggle here. The final case of the Court of Appeal is the National Union of Professional Foster Carers and Certification Officer case. Now, we submit that that case needs to be treated with great caution for three reasons. First, the Court of Appeal regarded itself with some diffidence as bound by earlier authority to the effect that foster carers don't have contracts. And for that reason, the case went off on a very artificial basis, and we can see that from Lord Justice Bean's judgment, his short concurring judgment at the very end of the case, where he says, this is at page... Give me, yes, page 2484. He says at paragraph 154, the complexity of the issues in this case derives in no small measure from W and Essex County Council. As has already been noted, para 50 of the judgment of Lord Justice Stuart Smith held that there was no contract between the local authority and the foster carers, saying if there's a statutory obligation to enter into form of agreement, the terms which are laid down, at any rate at their most important respects, there's no contract. And then at 155, he continues, this is puzzling. There are other types of work, such as teaching and nursing, where pay and conditions are determined nationally pursuant to statutory powers and cannot be varied by the parties. Divisional court decision concerned the nature of the relationship between electricity supplier and the customer. Entirely different topic. The doctrine of precedent means we're bound by W and Essex, as this court and all lower courts and tribunals have been for more than 20 years. But I respectfully suggest that it may require reconsideration either by the Supreme Court or by Parliament. And Lord Justice Underhill says a very similar thing at paragraph 152. So they did 152. They didn't like it, but they were stuck with it. So the case went off on an artificial basis. Then, in addition, of course, they didn't have the benefit of Uber. Had they had the benefit of Uber, one does wonder, applying the principle of the purpose of the legislation, that would have been an easy and obvious way to get the result they wanted to get to. And finally, the third point we'd make about that case is that it makes what we submit as the same error in interpreting Strasbourg as having said that Article 11 requires, in some cases, positive access to compulsory collective bargaining. So we do say that that's very much an outlier, and indeed was seen as such by the judges who decided it. Very quickly then, I have two final headings. My heading number 4 is justification. And on that, we do submit one has to treat justification and the margin of appreciation with some care in cases of this sort. It's important to distinguish between the kind of justification which it's realistic and appropriate to seek in a case such as this, where one is looking as to whether a statutory scheme balancing competing interests is compatible with the state's obligations, that kind of case on the one hand. And the more obvious case for justification, which is where a measure directly interferes with a convention right, the kind of negative right case. The example cited most often, Bank Mellat and HM Treasury. There, an order was made preventing anyone dealing with Bank Mellat and direct and obvious interference with their Article 1, Protocol 1 rights. And the question then is it justified? And one goes through Lord Sumption's 4 questions about whether a less intrusive measure would have been appropriate and so on. There one can understand the 4-stage test of Lord Sumption being apposite and practical. We're not really in that territory here, because there is no act or measure or provision actually striking into the rights of the union in this case. What there is a carefully calibrated and designed statutory scheme which inevitably has limitations and exceptions. And in that context, we submit that given all of the case law, both in Strasbourg and domestically, which emphasises the margin of appreciation in this area, one would require something very, very striking and egregious to say that any interference, if it arises, which we say it doesn't, was not justified. We come back to what Lord Justice Underhill said in Booth. One can't, as it were, nitpick with the legislation. And therefore we say that it's a very, very low hurdle in terms of justifying this scheme, which we would say has stood the test of time, carefully balances the competing interests, adopts a perfectly workable, clear and sensible definition of worker, and is not to be castigated as an arbitrary interference with the rights of anybody. It just confers rights on some people in some circumstances, and what's wrong with that? Finally then, reading down, and on that I can be very brief because we adopt the submissions of my learned friend Mr. Jeans. This is not a case like Vining, where you can just say parks constables should be treated as falling within the legislation, or a case like Gillam, where you say judges should be treated as falling within the ambit of the whistleblowing legislation. Here, the appellants are inviting the court to engage in a legislative exercise to redefine who a worker is under domestic law. As things stand, we have Lim A, the contract of employment, with its decades of case law as to how one differentiates a contract of employment from another case. We have Limb B, which has now been around for a while, and again, extensive case law on its ambit, culminating in the decision of this court in Uber and Aslam, saying you take a purposive approach, you look at dependence, subordination, control. All of that, the appellant suggests, should be swept away and rewritten. And in my submission, that would amount to impermissible judicial legislation. This definition has been chosen by Parliament and carefully developed by the courts. One cannot start to unpick it so that these particular workers, or as the CAC found, non-workers, these particular individuals, somehow come within it. There is no draft that one could produce. I mean, at first instance, there was an attempt to do this, but it didn't work. If, very briefly, before I sit down, we look at Mr. Justice Supperton's judgment at first instance, where he considered this, paragraph 60, which is in the core bundle, page 240. First instance, Mr. Hendy put forward, this is paragraph 60, put forward various ways in which the definition of 296 could be construed, and he put forward 3 options. Option 1 was that the findings of the NC that the workforce did normally work by way of personal service meant that they should satisfy the definition. So that would involve redrafting the legislation from personal service to normally working by personal service. Now, Parliament may in due course wish to do that, but it's not with respect, we would respectfully submit for the court to take that decision and redraft the legislation. Then at paragraph 62, he suggests a different test, which is the dominant feature of the contract personal performance? Again, we would submit that would be the court legislating. And it's all, of course, wholly unnecessary in circumstances where Lord Leggatt in Uber has, as it were, liberated tribunals and courts to adopt a substantive, purposive approach in looking at who falls within it. The statutory wording remains. You look at who the legislation is there for, but one needn't go any further than that. But we do submit that even if the appellants succeed at every other stage of the analysis, this can't be a case where one can read down Section 296 without engaging in judicial legislation. My lords and my lady, unless there's anything else I can assist you with, those are submissions on behalf of the Secretary of State.
The third option seems to involve taking a definition from a completely different context.
Yes.
Yes.
Yes. From homeworking, which didn't. And to be fair, I think Mr. Justice Supperton recognises that Lord Hendy didn't press that option.
Right.
Do we know how often, if at all, the compulsory procedure in Schedule A1 has actually been operated?
Well, we do, because we have the decisions of the CAC, which are publicly available and I think are on its website and have been...
Well, no, I don't mean the recognition stage, but actually that whole process that was described about making people bargain collectively.
Well, I can't answer that question. What I can say from my relatively limited experience of appearing before the CAC is that there are a series of questions which the CAC decides. Bargaining units, membership. One goes through these hoops. What tends to happen is one goes through a certain number of them, and there comes a point when sometimes the writing's on the wall and therefore the parties at that stage, reach agreement. I don't know how many of those stages, how many times one gets to the very end, but I would simply note that it's the fact that compulsive option is there, which no doubt
yes, of course,
is something that weighs on the parties' minds.
Thank you, Mr. Stelling.
Thank you very
Grateful.
Yes, of course, John.
Lords, milady, I propose to go through the submissions of my learned friends in the order in which they delivered them, not commenting on all, but just some points. First of all, Mr. Jeans makes some points about Section 296(1)(a) and makes some implications about the reasons why these riders didn't avail themselves of it. The short answer to that is neither Deliveroo nor the riders ever considered themselves to be employees. The issue only ever was, are they LIM-B workers? My lords, my lady, Lord Stevens contrasted the sole test in Section 296(1)(b) and the Article 11 multifactorial approach, and we thought that the contrast was useful. It's perhaps worth bearing in mind a point I made in opening, that but for the substitution clause in this case, it's quite clear that these riders would have been regarded as workers and would have crossed the threshold to avail themselves of the Schedule A1 machinery. And in that regard, it's exceedingly unlikely, we respectfully submit, that the European Court of Human Rights would consider them not to be in an employment relationship in those circumstances. And for the European Court, of course, the substitution clause or the personal service element could only ever be one factor amongst many other factors. Mr. Jeans expressed some views on those other factors. Those are his views. They are not the findings of the CAC, which did not consider the various other matters that Mr. Jeans raised. But nevertheless, looking at recommendation 198, it's quite clear that these riders were under the instructions and control of Deliveroo. In the first place, the training which was delivered by Deliveroo, and I quote paragraph 146 of the CAC decision, contained, quote, detailed videos containing instructions on how to carry out the role, unquote. It's also quite clear, as part of my opening was, that the instructions were given once an order had been accepted. The instruction was to go to a particular restaurant and deliver to a particular customer. That is clearly instructions and control. Integration was another factor under 198. These were the face of Deliveroo, as the CAC found. They were integrated into it, and Deliveroo said that they were the heart of the business operation. The work was conducted for the benefit of another person, for Deliveroo. Lords, my lady, even employment under 296(1)(a) consists of benefits to various parties. The shop worker benefits the shop owner, benefits herself or himself, and benefits the customer as well. There are often other beneficiaries, but what 198 is talking about is the worker conducting business on his or her own account, or primarily for the benefit of the person standing in the shoes of what would otherwise be the employer. workplace specification or...
Sorry, Lord Hindley.
I'm so sorry, my Lord.
The difficulty about there not being any factual findings in relation to these factors is because the argument wasn't raised properly. What are we supposed to do now in relation to the factors? I mean, I certainly know what the Strasbourg court would do. They would look through the various factors and they would decide the case.
Yes.
And they may do so on the basis of Yodel. But what are we supposed to do?
Well, my Lords, all I say is that we can't accept Mr. Jeans's submission that these elements were not fulfilled. It's a multifactorial approach, and some factors go one way, some factors go the other, just as in the Good Shepherd. But I accept, of course, what your Lordship says. Lords, other matters raised by Mr. Jeans were the fact of working for competitors, turning down jobs, and the riders can wear what they like. All those are factors which employees sometimes share as well. There are many employees who have more than one job. In fact, I looked up on the ONS website this morning, 1,219,000 workers in the period December 2022 to February 2022 have more than one job. Of course, we don't know whether they're employees or LIMB workers or a combination of the two, but it's the fact that workers have more than one job is not necessarily associated with whether or not they have a contract of employment.
But there's all the difference between having two jobs and working for competitors, isn't there?
Well, yeah, if one puts it like that, my Lord, but lots of cleaners, one knows, works for one cleaning company in the morning and another in the afternoon. They may be said to be competitors, but the worker is only taking what has been offered to her or him. The fact that they're competitors in our submission doesn't take the matter very much further. At any rate, these are factors, as Lord Stevens says, for the assessment of the European Court of Human Rights in applying its multifactorial approach. But we say, underlying all that, the key to this is the purpose of Article 11, which is the protection of the interests of the workers by trade union action, in particular by collective bargaining, in a situation where the bargaining position is unequal. And in this case, of course, the inequality was hopelessly so. Lords, turning to the question of European law, Mr. Jeans relies on the Yodel case. I'm not going to invite your Lordships to take it out now, but it's worth noting that the applicant's claim in that case was to be an employee, not a LIMB worker. One can see that from paragraph 14. And it's in that context that it appears to us that the Court of Justice is looking at the nature of an employment relationship, and one can see that from paragraph 30. Ultimately, the question for them was whether there was subordination in the relationship between B and Yodel, and one can see that from paragraph 43. And in relation to Yodel, I just make these additional few points. This, so far as we can see, firstly, is the only EU case to consider a substitution clause or that a worker is required to render personal service, whereas many cases have reiterated the essential criteria of subordination summarised in the Allenby case. Secondly, the CJEU were considering whether the claimant was a worker for the purposes of the Working Time Directive. Of course, the purpose of the Working Time Directive is the protection of workers, but it is a different kind of protection to that which Article 11 is protecting, namely trade union rights and a protection exercised through the exercise of trade union action. And we say that Yodel is no more likely to be indicative of the view of the European Court on that question than the UK domestic decisions. Thirdly, no consideration was given in Yodel to convention law, and in particular Article 11. Fourthly, as my learned friend pointed out, Yodel is a reasoned order without the benefit of any submissions from the parties or from EU governments, or, in particular, an opinion from the Attorney General. It's right that the Attorney General was heard, but as my Lady Rose commented, we don't know what the Attorney General said, and it's not in the usual form of a written opinion. Fifthly, the tribunal had held that the fact that the couriers had the possibility of subcontracting precluded their classification as a worker under domestic law, but neither the tribunal nor the Court of Justice considered the impact of Pimlico plumbers, because, of course, that decision postdated Yodel. Sixthly, the decision was primarily based on the construction of the contract and not on the purposive construction of the law, which would apply in the United Kingdom and which we submit guides the European Court. And finally, seventhly, the Court of Justice was primarily examining whether the relationship was one of subordination. Lords, I turn from that to mention the case of Kunston, which your lordships were taken to by Mr. Jeans, tab 1, page 3071. I don't invite you to take it up, but we do invite you to look at paragraphs 36, 37 and 42, which Mr. Jeans didn't have time to take you to, and I don't either. But the upshot of it was this, that if the self-employed workers were engaged on the same activity as employees engaged by the same employer, then there would be no breach of competition law. The long and short of that is that a collective agreement can, under EU competition law, to that limited extent at least, cover self-employed workers.
What's the page number for the case?
Constant is tab 71, page 3071, Lord.
Well, I've got
It's Beck2.
Beck2 there.
Yes. That's the same. Is that the same case?
It is.
FNV Princeton
Okay.
Media something or other. 3073. Oh, I've got the wrong page. Sorry, yes. It's FNV Constant Informatie and Media and Netherlands 3073, tab 71.
Very much indeed, thank you.
Yeah.
Lords, Milady, in any event, it appears to us that employment relationship for the purposes of EU law is not necessarily the same as the employment relationship which the European Court of Human Rights was considering in relation to Article 11. My learned friend Mr. Jeans said to your lordships, and in particular to my Lady Rose, that Article 11 rights were confined to employees who in English law would be under section 2961A only. And in fact, that theme runs through his submissions, but the argument in our submission is completely unsustainable. It's quite clearly wrong, because when one looks at the authorities, Article 11 is not confined to employees. Even in the Good Shepherd case, the priests were expressly not employees. They had contracts of employment, but they were terminated and another arrangement took their place. ILO 198 clearly goes further than simply employment. And the other Council of Europe jurisdiction, the European Social Charter in the Irish case that I cited to you, is explicit that self-employed workers must have the right to bargain collectively. Manole is yet another case where the right to form a trade union was not confined to employees. And likewise, in National Union of Professional Foster Carers, they were not employees. They didn't even have a contract of employment. Learned friend cited to you in a case that he handed up, the case of Avatins and Latvia, perhaps it's Avotin, and I wanted just to draw your attention, I mistakenly attempted when Mr. Jeans was on his feet, to a passage from Michaud at page 118 of the judgment. This is setting out the approach to European Union law. And if I take it exactly halfway between the hole punches, there's a line which begins, in the light of any relevant change in fundamental rights protection, if your lordships, your ladyships.
Paragraph 118 of Avatins.
118 in cited paragraph 103.
It's page 118, and it's a citation from Michaud.
Exactly so.
And it's paragraph 103 of Michaud.
Yes, and it's paragraph 103 to which I drew it.
However.
103 from Michaud.
Yes.
And I invite the court to look halfway through the main body of that paragraph. There's a line which begins in the light of any relevant change, and the sentence beginning at the end of that line is, if such equivalent protection is considered to be provided by the organisation, the presumption will be that a state has not departed from the requirements of the convention when it does no more than implement legal obligations flowing from its membership of the organisation. However, a state will be fully responsible under the convention for all acts falling outside its strict international legal obligations, notably where it's exercised state discretion. In addition, any such presumption can be rebutted if, in the circumstances of a particular case, it's considered that the protection of convention rights was manifestly deficient. So the fact that EU law it was followed by a state is not necessarily excluding the scope of the convention.
Well, Henry, I'm sorry, but I would be greatly assisted if I could just try to orientate myself around where you are at the moment, as it were, because my understanding is that you accept there has to be an employment relationship in order to come within the scope of Article 11. And
well, I put it more broadly, my lord. I put it there has to be a purposive relationship of which the employment relationship may be a sort of form of shorthand, or in the context of an employment relationship, which indicates that we're looking at occupational interest to be protected by trade union action. Yes.
And you, as I understand it, there's no interference with the riders' right to join a trade union, because they can do so, they're free to do so. Your union, your clients will accept that.
That's right, my lord. But as the European Court has made absolutely clear, the right to join and form a trade union is not confined simply to holding a membership card. It extends to other rights as well.
But you also accept there's no positive obligation to have compulsory collective bargaining.
I absolutely agree with that, my lord. I'm going to address that in just a moment.
And the argument then that's put forward against you is there's absolutely no breach of any right because to require justification. Well, because there's no right to have compulsory collective bargaining, there's no breach, there's no requirement to justify.
Will your lordship forgive me if I just finish off this point and come to that in just a minute? It's an absolutely central argument, I agree.
It is. Well, I'd be very informed.
I'm not going to sit down before I deal with it,
yes.
my lord.
Right. Well, don't. Yes.
No, my lord, just concluding on that was my conclusion on European law and the matters raised by Mr. Jeans. He then looked at Uber and a purposive approach. He cited the case of Simply Smile, we agree with the way that His Honour Judge Auerbach put it in Simply Smile. It appears to us that that simply supports the argument that we put forward of a purposive approach to these matters. Mr. Jeans drew attention to the facts in Uber and pointed to differences in the facts in our own case. I accept, of course, that the facts are different. And so is the right which was claimed there, which in that case was the national minimum wage. It was not a claim for trade union rights. The significance of it in our respectful submission is that it provides an analogous, purposive approach for that which the European Court of Human Rights adopts in relation to these Article 11 cases. And Mr. Jeans, going on in his submissions, says that the cases show that Article 11 is restricted to employees, and in that context cited Damir, which is at page 2888, in paragraph 154, where your lordships and your ladyship will recall that the paragraph spoke of collective bargaining with an employer. But Mr. Jeans didn't read on in that paragraph, and I leave the court to do so, because the next sentence reads, like other workers, civil, I can't remember, local authority workers, like other workers. So it's clear that the European Court had in mind workers and not employees. He cites Viking and the IWGB as being concerned with employees, and of course they were. That was the factual basis of their status. It's not surprising, therefore, that in those cases no consideration was given to any wider scope of a person carrying out work than simply employees. In Manolo, which my learned friend dealt with, he points to the paragraph 62, which described the organisation as a trade union type. But, my lords, I invite your lordships to make a note of paragraph 57, 59, 60, 61, 63, 65, and in particular 71, because it's quite clear that the European Court there referred expressly in every one of those paragraphs to a trade union and made their decision on the application of Article 11.1 in relation to the trade union which those self-employed farmers wanted to set up. Lords, I come now to this crucial question of compulsory collective bargaining. It's our submission that my learned friends have set up a person of straw. It's an argument we have never made, so far as I can recall, and I've been in this case as long as Mr. Jeans, over many, many years, that there is a right under Article 11 to require a state to provide compulsory collective bargaining. And therefore, Mr. Stillett's evidence showing a lack of consensus on compulsory collective bargaining is completely immaterial. It's always been our position that, and it's such a simple proposition, I say it again, where the state is elected to establish a mechanism under which citizens can exercise convention rights, then to the extent that certain citizens are excluded from that, that will engage the relevant provision of the convention and will have to be justified. In this case, the state has erected a compulsory collective bargaining mechanism, machinery, and said that certain workers are not entitled to it. Now, some of the restrictions on entitlement to collective bargaining are clearly justifiable. The number of workers, minimum number of workers, the fact that collective bargaining under the machinery is confined to pay hours and holidays, and other constraints which Mr. Stillitz hinted at in that very long text of Schedule A1. But this is the same, and it really arose from discussion with my Lady Rose yesterday. This is akin to a local authority setting up a public swimming pool. No duty to do so, but if they do so, they can't exclude people from it in breach of those people's convention rights. If they said that it was only open to white people or only open to men or something of that kind, the local authority would clearly be in violation of the relevant convention rights, Article 14 and so on. And that is the simple point that we make. In this case, the state has erected Schedule A1. If it hadn't erected that, we would not have a case before this or any other court to claim that there should be compulsory collective bargaining. That is the substance of Unite and United Kingdom and the passages that Mr. Jeans showed you. And I don't seek to go behind it, and I don't challenge it in any way here. But once it's been erected, then having been shut out, we say that there is a violation of Article 11.1. Of course, we've got to demonstrate that our 11.1 rights are violated, and if they are, we then consider whether or not our exclusion is justified.
But which is your 11.1?
I'm so sorry.
Which is the 11.1 right that has been
the 11.1 right, my lord, is the one articulated in Wilson and in Damir. It's the right deriving from trade union membership for the protection of the workers' occupational interests by collective trade union action, and in particular collective bargaining.
But we're talking here about compulsory collective bargaining, and you accept that Article 11.1 does not confer a right on someone in an employment relationship to a right to compulsory collective bargaining.
It doesn't confer on us a right to require the state to provide compulsory.
I mean, Demir is clear. There are. I mean, the right to join and to form a trade union carries with it certain rights, which include voluntary collective bargaining.
Yes.
So a denial of voluntary collective bargaining is a denial of an Article 11.1 right.
Indeed.
But here you start with something that isn't an Article 11.1 right, and then you say in your argument, but you get to a point where there has been a breach of your Article 11.1 right, and that's the difficulty.
I see what your lordship's saying, but the right under Article 11 is a right to bargain collectively. The words voluntary or compulsory don't enter into it. And where the state's erected a machinery for that to be conducted, on the face of it, we say that that is a violation of Article.
Yes, and you rely on Unite the Union and Boots and so on for that.
Yes, well, it's Damir, really, my lord. It's Damir.
But is that because you say that once the state has erected the machinery, you don't any longer have to rely on a positive obligation? Then you're only saying, once we've got over that hurdle, then it is the negative obligation not to interfere with the right that you've conferred, so you don't have that uphill struggle to which
your ladyship puts it more elegantly than I. But that's exactly what our submission is. Lords, my lady, the argument is, as my lady says, the negative right not to be excluded from collective bargaining. And of course we accept that in international law, not only is there no right to compulsory collective bargaining, there's no bar on it either, so long as the parties are enabled to voluntarily take up whatever position they wish in the negotiations. And therefore, turning to a point that was raised with my learned friend, Mr. Stillitz, there's no compulsion to enter a collective agreement, for example. That would be a negation of Article 11 rights, or it may be a negation of other rights under the Convention. And we've never sought to say that we've got a right to obtain a collective agreement with Deliveroo. All we want is the opportunity under the ship to sit down with them and see whether they'll listen to our persuasion or not. And if they don't, that ultimately is the end of the matter. Lord, my lords, my lady, I think Mr. Jean said at some point that there was no precedent for any state intervention. We've tried to set out in that opening to our case that there's been a long history of state intervention in collective bargaining, really going back to the 1894 Fair Wages Resolution, but I won't take time on that now. We disagree with both my learned friends in their interpretation of the reasoning of Lord Justice Underhill, which led to his conclusion at paragraph 54, which was accepted in Vining and in National Union Professional Foster Carers. We think that he was addressing interference rather than justification, and that Mr. Jeans elided those two concepts. But, my lords, we leave it to your lordships to look at the chain of reasoning which flows from paragraph 33 through to his conclusion at 54. It's Boots, tab 41, page 2151. Lords, Mr. Jeans made a point about pay hours and holidays and suggested that we weren't in a position to negotiate hours and holidays because of the nature of the employment. I won't take time over that, but clearly it would be possible theoretically for these workers to argue for holiday periods or for a limitation on hours, but whether or not that's the case, quite clearly they have got the wherewithal to argue about pay. They could ask for an increase in the fee per delivery. They could ask for the Battersea arrangement of an hourly rate plus a fee per delivery. They could ask for simply an hourly rate. Mr. Jean seems to think that most of the riders are students, but there's no evidence of that in the CAC, and indeed at paragraph 102, your lordships, your ladyship will recall that they found that many riders do as much work as possible. Lords, my lady, so far as justification is concerned, I'm not sure there's more I want to say than we put in our case, and I opened to the court yesterday. So far as reading down is concerned, I think your lordships, your ladyship have our submissions on that. This is with the grain. It is the purpose. It is to protect workers. To the extent that the sole test in 2961A is mitigated in respect of those who under Article 11 are entitled to bargain collectively in respect of pay, hours and holidays, really it's no different to National Union of Professional Foster Carers, where an even more fundamental issue, namely whether or not they had a contract at all, was overcome by reading down section 296(1)(a). And your lordships and your ladyship have our submissions about the way in which if precise words are needed, the section could be read. It's in our skeleton argument to the High Court at pages 102 to 111, slightly embellished in the Court of Appeal at pages 323 to 325. Well, two final, rather small points. That is that Mr. Stillitz said in relation to Uber, the question really boils down to this. He said, who did Parliament intend to benefit? And we say, analogously, under the European Convention, Article 11, who was that intended to benefit? Bearing in mind that unlike Section 296, the Convention is a living document which has to evolve to take account of modern developments, including, of course, the growth of gig work through technology, including apps and mobile phones and so on. And the final point which I wanted to make to the court was in relation to the case of RMT. Again, it's a small point, but one that is I've found niggling in many cases. It's in paragraph 86. The court needn't look it up now, but as Mr. Stillitz read it, the court was there saying that it was a crucial thing that Damir dealt with a dissolution of a trade union. And he said, of course, that it was a dissolution of a collective agreement. And he's right. That must be a typographical error in the report of the judgment. There was no dissolution of a trade union in Damir. It was the fact that the collective agreement was considered null and void. So the relevance of that is that collective bargaining reassumes its central position in the judgment of Damir. It was a core right to use the language of RMT in the very next paragraph, 87, and therefore one which merited, in that case and in this case, the protection. Lords, unless my learned juniors tell me I've missed something critical. I know I have missed things, probably all critical, but doing the best I can in the time available.
We're very grateful to you, Lord Hendy, and to all counsel in the case and all solicitors. It will not surprise you that we will take time to consider our decision in this most interesting matter. Thank you all very much.